Hello everyone, welcome to Legal Darshan. In today's video, we are going to start a new topic, that is Transfer of Property Act 1882 and Property Law. We will be covering several cases under this ambit to understand the concepts of property law. So today we are going to start with the case of Srimati Shantabai versus State of Bombay. In this case, a lease deed was executed in favor of the plaintiff for 12 and a half years, that is from 1948 to 1960, for which she paid a consideration amount of rupees 26,000. Now the twist arises when the lease is found to be unregistered. So the facts of the case is the deed was executed, however the deed was unregistered. It allowed the plaintiff to cut woods and bamboos and take the fuels out of a particular land in the forest which was allotted to her. So it was a condition that when the trees will be 1.5 feet long, she will be able to cut them. However, what made the case come in front of the court was Madhya Pradesh Abolishment of Proprietary Rights 1950 came into existence, through which the divisional officer prevented the plaintiff from cutting trees in that area. She went to the government of Madhya Pradesh also, which upheld the decision of divisional officer as nothing tangible happened while she filed a complaint before the government of Madhya Pradesh. Therefore, she made a writ petition in Supreme Court of India under Article 32 on August 26, 1957. So now the issues that Supreme Court has to resolve in this case are that if she was prevented from cutting of trees, were her fundamental rights have been violated, because she has filed a complaint under Article 32 of Indian Constitution and about what timber is a movable property or an immovable property. Because in this case we will be referring to Section 3 of Transfer of Property Act 1882, and the court looked at the precedent cases of Chotabhai Jethabhai Patel versus State of Madhya Pradesh and Ananda Behra versus State of Orissa. However, the case relied more upon the judgment of Ananda Behra versus State of Orissa. So what Section 3 of Transfer of Property Act talks about, Section 3 is an interpretation clause which has defined immovable property as the type of property which does not include standing timber, growing crops or grass. So if immovable property does not include standing timber, growing crops or grass, does it come in the ambit of movable property? We will be finding this out. Another word that has been interpreted in the Section 3 of TPA is registered. Registered means registered in any part of the territories to which the Act extends under the law for the time being in force regulating the registration of documents. So the document should be registered in any part of the territories so that it could be enforced. And another term we will be looking at in this regard is attached to the earth. Attached to the earth has three meanings. First, that the thing should be embedded in earth, like the wall or buildings, like they are being embedded. The other thing is rooted in the earth, like they have their roots in the earth, like trees and shrubs. And the third meaning to this is something attached to what is embedded, like we have a building, we have a door attached to it, so that thing is also attached to earth and becomes immovable because the door is attached like a property which is for the permanent beneficial enjoyment of the embedded thing. Like if a door is attached to building, that is because it is paying some use to the building, right? So a door will be an immovable property until it is attached to that embedded building. But when the door, someone has already cut the door down, it is lying on the ground, it becomes a movable property because it has already been cut. So if a thief steals it away, we cannot say that he has stolen an immovable property because the door was already cut down. Suppose there was a construction going on and someone just unlocked the door from its hinges and put it down on the pavement, and someone took it off thinking ki there is a door lying and let's take it off and I'll sell it and make some money. Then the thief has stolen a movable property, because when it got unattached to the building which was embedded in earth, it becomes movable. Until and unless it is attached, it is an immovable property and it is attached to earth. Okay, so these are terms we will be keeping in mind while studying the case of Shantabai versus State of Bombay. So moving further to the case, as the facts I have already discussed, that there was an unregistered lease deed for land of forest to cut timber, bamboos and take the fuel out of it for 12.5 years, for which the plaintiff has paid a consideration amount of 26,000 in 1948. So later, after 2 years, in 1950, an abolishment of proprietary rights was issued which prevented the lady from cutting trees. So she challenged in court that her fundamental right has been violated. Now coming on to the issues, let's see how the court is resolving it. The court has inferred out of Ananda Behera's case that the petitioner's right were not more than the right to just obtain goods. Therefore, it was not a personal right. It was a right that was coming out of a contract which was even unregistered. In this case, the deed was not even registered, so it was only a contractual right. Had the deed been registered, it wasn't even the violation of a fundamental right, but only a breach of contractual right. So this cannot be regarded as a breach of fundamental right. The court says that to bring this claim under a right to property, which for your information is now being struck out of fundamental rights and has been put into the constitutional rights under article 300A. So we will just because at that time it was there, it is said that the claim was brought under article 19(1)(f) and article 31(1), right to property. So right to property has been struck out of fundamental rights, but she didn't even have right on the land because it was a lease deed which was obviously an unregistered one, and in the lease deed the estate was the sole proprietor. Then article 19(1), which is the right 19(1)(f), which is the right to work, then even it is not violated because the reason lies same. The deed was unregistered, it was a lease deed, and thirdly it is purely a breach of contractual right, not a fundamental right. However, the another question was, is the timber movable property or immovable property? Now the court is looking at a difference between what is a standing timber and what is a tree. So the exclusion was only of standing timber and not of timber trees. Only if we go by the language of TPA, it is stated that standing timber is not covered in the ambit of immovable property. It doesn't mention timber trees because standing timber is a tree. It is in a fit state to draw sustenance from the soil. Unlike timber is like, you cannot alter the name, you cannot alter the physical aspects of a tree, that it is drawing sustenance from the soil as long as it is standing and living. just by naming it standing timber and making it a movable property. So the court is bringing a distinction that a tree can only be regarded as standing timber when it is in a state that if it is cut, it could be used as timber, and then only it must be cut. So one cannot cut the tree at a premature age and say that I have cut a standing timber. For a tree to be a standing timber, it has to be fall in a state where if cut, it could be used as timber immediately. So now how does the document in question regard this? The deed was for 12 years, hence in 12 years the timber can be trees of timber can be mature enough to be called a standing timber. Now where does the problem lies? So the result is that even though such trees can be called as standing timber at the date of document, both because of their size and girth or also because of an intention to be felled at an early date, they would be movable property for the purpose of transfer of property. They were called as movable property, but the deed of 26,000 rupees consideration was unregistered. It was not registered. It required the registered, and it was not only just timber trees in the matter, it was also bamboo trees and other trees which they got the permission to cut down. The court has declared the trees as standing timber and as a movable property for the purpose, but other trees were immovable, and the grant was of total value of 26,000 which required registration. So being unregistered, it had no titles of interest, and therefore just as in the case of Ananda Behra, there were no rights found, there were no fundamental rights was found in her case which she could enforce. The bench passed similar judgment and dismissed the matter. So what we can summarize quickly is that the case has been it was all the matter of not getting the deed registered. So the issues have been resolved that it was not a violation of any of her fundamental rights. The timber trees were here referred as standing timber, and thus they are covered in the ambit of movable property. The court dismissed her petition because the deed was unregistered and hence held no value in front of the law. So that is all for today's video. Please like, share and subscribe, and also don't forget to give us your feedbacks at legaldarshana@gmail.com and in the comment box below.